Hi, I'm here with Kim Rooney. Kim, you are the go-to person on the Law Reforms Commission's report on third-party funding. Can you explain a little bit about your role with that? And secondly, can you tell us what some of the highlights are in the report itself?
Well, thanks very much for that. But I'm the chair of a subcommittee of the Law Reform Commission. The other members included Justin D'Agostino, Teresa Cheng, Victor Dawes, Robert Pang, and Jason Carras, and our secretary was Kitty Fung, but we got huge support from the Law Reform Commission, various colleagues there, and the Legal Drafting Division. So that's just a preamble. This has been a 3-year exercise. We were given terms of reference by the Law Reform Commission to look at the law and see whether or not it needed to be amended to allow third-party funding for arbitration. What are the highlights? The highlights are that the final report of the Law Reform Commission that was released last week in October 2016 recommended that very ancient doctrines of championship and maintenance should not apply to third-party funding for arbitration and shouldn't apply to other proceedings. It's quite technical under the arbitration ordinance, such as emergency arbitrated proceedings, mediation under the arbitration ordinance, and also litigation under the arbitration ordinance. Why did we recommend that? To maintain Hong Kong's competitive position and to serve users, because this, in nearly every other international arbitration centre in the world, it's allowed. There's one place in Asia that doesn't allow it yet, but they've said they will. What are the highlights? One, that third-party funding for arbitration should be permitted and that the doctrines of maintenance and championship shouldn't apply. The arbitration ordinance needs to be amended to reflect that, but that there should be standards, financial and ethical, that apply to that third-party funding. Okay, how do we do that?
Right.
We've advocated a light touch, what we call a light touch approach, which I think is consistent with international practice. What does light touch approach mean? Light touch approach means that if this goes through, if this is implemented, the doctrines of championship and maintenance will no longer apply to third-party funding. So there won't be potential for criminal offences, there won't be civil claims as such. However, what we're recommending is there should be a code of conduct that's third-party funders who are providing funding in Hong Kong should comply with. And we've set out in draft, the Law Reform Commission has set out in draft legislation at the end of the report the framework for that code. The code is yet to be published, but it will be first published in draft, or we've recommended it should be for public consultation.
What has been some of the fears with moving forward beyond the laws of championship and maintenance? What's been sort of the holdback?
These doctrines developed 700 years ago or more because of a concern that people who had no connection with a particular litigation would invest in it to make money, and by doing that could affect the integrity of the process. Because it was considered that litigation should be the resolution of legal claims between parties who had legal claims. People shouldn't trade in them, or shouldn't otherwise make profit out of them who had no real interest in them. But that's 700 years ago. The legal system's robust. There are lots of protections to ensure the integrity of the system, so the conditions have changed. And England abolished championship and maintenance of criminal offences in 1967. Australia allows it now. I'll spare you the shopping list. It's generally allowed.
So is this a good thing for Hong Kong?
The implementation of these recommended reforms, in my opinion, will be a good thing for Hong Kong because we need to do it to maintain our competitive position and to meet the needs of users of arbitration. We need to be able to give people this choice in Hong Kong.